Today we're going to look at employment law issues that are fairly unique to healthcare providers. Some of them, of course, occur in other workplaces, but we're going to focus in on what you as a healthcare administrator will likely confront. So let's talk a bit about some of the general topics. We'll talk about pre-employment screening. We'll talk about infectious disease, sexual harassment, religious consideration, workplace monitoring, and workplace violence. Um, we won't get terribly deep into any of these topics because each of them are a class unto themselves, if not an entire course. So we're going to hit kind of the highlights, and there's further information available in your readings as part of this course. So let's look at pre-employment screening. Pre-employment drug testing certainly is legal and legitimate um, once the offer of employment has been made. And that is the case with most pre-employment screening. These can't take place until the employment offer has been made. Next is other types of testing. Very challenging to finesse a way to be doing genetic testing these days prior to employment. That is very much frowned upon, and there is what's referred to as the GINA Act, G-I-N-A, that in essence prohibits that. There you can do a fitness for work sort of examination to see if a person can physically do the employment that you're seeking, but one must be careful of the ADA in that if someone does have a physical disability and is unable to perform a job, can they be reasonably accommodated? And that you get into challenging situations of trying to figure out what is reasonable accommodation, of course. The other issue is if you are wanting to do pre-employment disease screening, what is the basis for that? Why would you do that? One employer decided that they would do pregnancy tests on all candidates for a position without telling the candidates. That was found to be improper. Criminal conviction screening is vitally important in the employment area. In fact, is required by many state and federal statutes. There are what's known as the barrier crimes. So certainly doing a criminal background check is not only legal, but required in many situations. Credit reports are a little more fuzzy as to whether they are proper or not. Certainly many employers do them. The question may be, how is this related to the job that the person is being considered for? If they are a CFO, absolutely. If they are a bookkeeper, absolutely. If they are managing the DME equipment, is it that relevant? It may be. An emerging area of controversy is doing a check of social media accounts. First of all, you cannot force a candidate to give you the passwords to all of their accounts pre-employment or during employment. And the question is, what do you do if you do see information that is concerning to you on those social media accounts? Well, in some states like Virginia, it's an employment at will state, so one could be terminated for really pretty much any reason, whether that's social media or you don't like the color of their shirt or whatever else. But if you are a government employer, then you have additional hurdles to consider about restrictions of free speech and so forth. One also certainly is likely to and should consider references of prior employers for employees. In seeking references, it's perfectly legitimate to ask most questions that might come to mind. Many former employers are hesitant to respond to those questions and have kind of a stock answer of giving you employment dates and position title, and that's kind of it. But many states, including Virginia, have a statute that protects former employers if they give true and accurate information as to why an employee departed. So one should not fear being honest in those references. Obviously, infectious disease is going to be uh, something that your employees are going to be exposed to on a fairly regular basis in healthcare, and there is pretty strenuous regulatory guidelines that are in place to address that. First is the OSHA regulations, known as the Bloodborne Pathogen Standards. These were enacted in response to the HIV crisis. Um, they continue to be in force, even though people tended to forget about them. But they are very extensive, very burdensome, and require a whole lot of bookkeeping. For example, you may be required to keep records about your employees for 30 years related to their exposure to bloodborne pathogens. The second part of the conversation has to do with exposure to infectious disease. There is the concept that we've looked at previously in the informed consent section about deemed consent of testing a patient's blood for HIV or hepatitis or other disease if a healthcare provider is exposed. But there is also the concern these days of if your staff is exposed to an infectious disease, and one that is particularly virulent, whether that's the Ebola virus or even the flu, what steps need to be taken to control that epidemic, and that may require that a person or a facility be quarantined, which is a pretty drastic step, or a individual who is exhibiting symptoms may need to be put into isolation. You'll see a discussion of those two concepts of quarantine and isolation as a legal concept in the textbook, and I invite you to have a look at those. Let's talk a little bit about sexual harassment in the workplace. I appreciate that in many units, whether that is in the ER or even on the general medical ward or even in a nursing home, sexual harassment is not an unknown phenomenon, and it often comes from the patients themselves, maybe unwanted advances by fellow staff members, but it does occur in the workplace. There are certainly lots of state and federal laws that apply and are well beyond the scope of getting into all that in this short conversation. But your HR department needs to be ahead of the curve in education, in an investigation process, and in addressing claims of sexual harassment. The challenge is that the sexual harasser may be a resident of your facility or a patient of your facility, and you need to be in a situation of addressing that. There are a number of sexual harassment lawsuits where plaintiffs have prevailed in that a restaurant manager knew that the patrons were grabbing and pinching the waitress, and the manager failed to intervene. That certainly may be applicable to a hospital setting too, and so one needs to be aware of that. Managing through it is always a challenge in that you can't close your facility, you can't immediately discharge bad actor patients, and so you need to have a process of being able to manage through a sexual harassment situation. It may be that the CEO of your healthcare system is the harasser. How do you go about dealing with that? What is the process that you have in place for that? Religious considerations are an ongoing factor in healthcare institutions because there is a lot of interaction, as we discussed in our first units of this course, about the intersections of ethics, of religion, and of healthcare. And it comes in a lot of different situations, but quite often it may be your employees who have a particular religious perspective. And, can you use religion as a hiring criteria? And the answer is probably not. Even though you may run a religious institution, you can't only hire people of your religion unless there is a well-demonstrated reason why that has to be the case. For example, if you're looking to hire a Catholic chaplain, probably the Baptist and the Jewish chaplains don't fit that criteria. But if you're looking to hire staff in the ER, using a religious screen is probably inappropriate. The ongoing challenge is religion in the workplace, and it comes in a couple different flavors. It may be that you have a staff member who is proselytizing to coworkers, and the coworkers are not appreciating that. It may be that you have a staffer who wants to wear a particular religious garb or jewelry in the workplace. It may be that a staff member decides to whisper into patients' ears as they are being wheeled down to the OR her religious perspective on what's about to happen. For example, there was a case, and I'm sure there's more than one, but there was a case that was reported where a nurse was whispering in the ear of patients that they were going straight to hell if they had an abortion as she rolled them into the operating room. She was offered reassignment to the newborn unit or into some other units, and she declined, and therefore the healthcare system terminated her. The court upheld that dismissal because it was a reasonable action by the employer. We occasionally get into questions about healthcare garb. For example, our Muslim staff members may want to wear covering of their head, or they may want to wear a full burqa. The question there needs to boil down to an objective view of what interferes in the workplace. Do we have any concerns as far as infection control? Is there other criteria that would make that objectionable from an objective basis and not simply from a we don't cotton to that kind of religion in our place sort of criteria? We have to be sensitive to the fact of people exercising their religion if it is non-intrusive on other people's rights and on the safety of others. Let's talk a little bit about workplace monitoring. We see this happen more and more. Video cameras are in many of our hallways. They are in our emergency room entrances. They are in our lobbies. And the security team often wants to place them lots of other places. Well, if there is overt monitoring and it is clear, for example, there may be a sign posted in the lobby of the emergency room that this area is being monitored by video cameras, perfectly acceptable. And the same is true for employee workplaces. You may have cameras on your cashiers, just like they do at McDonald's, to assure that you get pictures of who is robbing the place, but also getting pictures of who may be taking money in or out of the till. The more challenging question is covert monitoring. There are certain places that are simply off limits. You cannot place video monitoring in changing rooms, locker rooms, other places where privacy is expected by your staff members for obvious reasons. But that is not always been observed. There are a number of cases where security have tried to place cameras as discreetly as possible to catch people stealing hospital equipment by putting it in their bags that they use to take clothes in and out of the hospital. They have put cameras other places, and those are certainly inappropriate. Interesting question that we did not cover in the section on healthcare information, but one that does come up are body cameras for your police officers, and depending upon your facility, whether those are security guards or if they're actual police officers. Outside police officers often come in with body cameras. Whether they're turned on or not is a matter of policy for the police department. It is something that needs to be negotiated with your local police as to when those cameras are used in your facility, because patients have a right of privacy. And that is a challenge because police officers are expected in many settings to have those cameras on, and balancing patient privacy and protection of the public and the police officer have to be discussed. Likewise, there are often efforts to put nanny cams in patients' rooms. So certainly this is a big move in long-term care, that families overtly or covertly place a video camera, much like the one I'm using for this presentation, in their loved one's room to watch the staff and the resident. Um, that has to be with the resident's approval if they are competent. If they are incompetent, then whoever the decision maker has to be aware of that. The family needs to be cautioned about discretion because anything that's electronic these days is subject to being hacked, is subject to be putting in the public world, and we certainly want to avoid that. You may have in a long-term care facility an allegation that a particular staff member is not appropriately caring for a resident, or the resident is suffering injuries. Be very cautious about using video monitoring in patient care areas because the patients do have those rights and should not be videotaped without their consent. Last but not least, the unfortunate fact of life these days is that violence will occur in your workplace, and the challenge is that you need to be prepared for that. OSHA has recently come out with guidance that expect every healthcare institution to have a plan in place for minimizing workplace violence, for de-escalating workplace violence, and for addressing the aftermath of it. These are not simple plans to put together because you're kind of trying to make a policy and procedure on the unknown, and it is very difficult to anticipate where that may come from. Is it an employee who is the perpetrator? Is it an outsider who's the perpetrator? And what is the nature of the violence that's occurring? The Joint Commission used to actually not want hospitals to have workplace violence policies. They have now jumped on board, as you might imagine, and it is a requirement of the Joint Commission. This is an evolving area because anticipating workplace violence and the ugly forms that it can take are entirely impossible to predict. Just when you think, gosh, we'll have a single person creating an issue, you may have an explosion that occurs in the facility. You may have a multi-shooter incident. You may have a biological issue that develop. All of those are difficult to plan for, but your institution needs to be prepared for how do we deal with a crisis within the facility. Managing through it is something that you should do in kind of tabletop exercises, running drills. But if you decide to run a drill, make sure that your staff is well aware that it is a drill. One hospital here in rural Virginia decided that they would get ahead of the curve and run a very realistic terrorist attack in an emergency room, but failed to tell their staff that they were going to do it. Needless to say, the outcomes were not what were expected. People who were play acting ended up getting injured. The staff was certainly traumatized, and it was not a well thought out process. That brings us to the end of our conversation about employment law practice. I appreciate that it was fairly shallow. Hopefully I hit on kind of a range of topics for you. I encourage you, if you are interested in the employment space of administration, to dig deeper into the topics. Each of them have lots of material that we could discuss. And certainly as an administrator, you need to be sensitive to all of those issues that we've touched upon.